So today we're going to discuss the 5 assets that should never be put into a trust.
We're the owners of Generations Wealth Partners, and we've helped retirees all over the United States secure their assets by avoiding the most common mistakes retirees make when creating and using a living trust.
And that's exactly what we're going to cover in today's video. Let's get after it.
Let's do it.
Okay.
So this is a fun one, Todd. I'm going to lean on you quite a bit here on this one, but
Since I'm the attorney, this is something that I see all the time.
and we should say, I'm sorry, let me just cut you off really quick. You're an attorney, but you're not their attorney unless they have a signed engagement letter. So,
exactly.
And I'm a financial planner, but I'm not your financial planner unless that's the case. And so we joke, but our goal is to educate and help people think through this a little bit better.
Yeah, this is general information that you should take to your appointment with an attorney to do your estate plan. So first of all, I think one of the biggest things, and I have found, thankfully, the investment company is good about this, that if you try to put your IRA or your 401k into your trust, hopefully your investment company will be, wait, no, I don't think you want to do that. And that is true.
Yeah.
You don't want to do that. And the reason being is, particularly with an IRA, that's an individual retirement account, the key word there is individual.
Mm-hmm.
It has to be owned by you, the individual, and it cannot be owned by a trust. That's just IRS rules, okay? And so number one, first and foremost, you cannot and should not put if you do put your IRA into a trust, it's no longer an IRA. So you cannot put your IRA into a trust.
And if you tried to, and hopefully they don't let you do this, but really what that would be you would just be withdrawing all of the money from it and putting it into a trust account, which would cause probably a significant tax burden,
Very big tax bill.
potentially some penalties as well. So don't do that, please.
So that one's easy. Okay. The second one, and this may not be in agreement with all attorneys, but I have found typically I do not put vehicles, cars, trucks, boats, trailers, things like that into a trust because of insurance reasons. Your insurance company generally wants to insure a person, not the device, or the vehicle. They want to insure you driving that vehicle or driving that boat or living in that RV, whatever. And so many times when you put that into a trust, it causes problems with your insurance company. And almost every state has a very simple process of getting a vehicle from a dead person to someone else or to a trust. And so typically that is something that in our state of Arkansas, there's a form that you can fill out now to say, at my death, this goes to this person.
Pretty straightforward.
Or the heirs, your children, typically can fill out a form after your death and say, this vehicle should go to these people. And so normally we will address it in the trust to say, hey, we would like for this vehicle to go to this person and this to go to these people, but it's a suggestion since the item is not specifically in the trust.
So are there any exceptions to that in your mind if it's like a classic car or really, high dollar vehicle?
Yeah, if it is something that you're not driving a lot, like the 65 Corvette or whatever, that is in a garage, or I even have one client now, he has a vehicle that is in a museum. He owns it, but it's in a museum. And so therefore I would think that the museum would have insurance on it, or he may have insurance, but it's not really for driving, it's on that vehicle. And so, yeah, there are many times exceptions to this, but almost always you don't want to put your vehicles or boats, trailers, things like that into the trust due to insurance reasons.
And I think another thing to just talk about here is, the purpose of a revocable living trust is really, as much as we can, to create simplicity when it comes to probate.
Yeah, so avoiding probate.
Really the purpose of it. We don't want that to happen.
Yeah.
And so, adding unnecessary complexity is really kind of going against the entire point.
That's not our goal. Yeah.
The opposite.
Not our goal.
That's
Keeping vehicles out of the trust, just in your name individually. And if it does go through probate, it's not a big deal. Most states have a limit as to if the dollar amount that is going through probate is under a certain amount. In Arkansas, which is a pretty cheap state, it's $100,000 or less. And so if you have $10,000, $20,000, $30,000 worth of vehicles having to go through probate, it's a very simple process. So even at worst, if it did have to go through probate, it is not a huge issue. Okay. The next thing which may surprise you is, and please, when I say this, don't think, oh, okay, I don't have to do anything with it. No, you do need to do something. But typically, I don't put homes, particularly with mortgages, into a revocable living trust. I know that sounds strange. And again, it's not the home or you, it's the mortgage company. The mortgage company should allow you to put a mortgage piece of property into a trust that you control and you benefit from. You can even put it into an irrevocable trust, but that's a whole nother video. So many times, if a home has a mortgage, I will not put it directly into the trust, but I do something because we don't want that home going through probate. In my state and in most states, there is a payable on death or a transfer on death provision, some kind of document you can do to make sure that at your death, this home goes into the trust. At that point, the kid, at your death, the kids probably don't want the house, or even if they do, they've got to figure out how to get it paid for. And if they don't want it with this mortgage, the home and the mortgage goes into the trust, and the trustee can then deal with the trust or the mortgage company, get the home sold, pay off the mortgage, be done with it. And the reason I do that is I just don't want my clients to have a due on sale clause evoked when we put it into the trust. The mortgage company says, oh, you sold the house to the trust, so therefore your mortgage is now due. And particularly today, this is September of 2024, interest rates are much higher. And if we're having to refinance a home that's at 2%, 3%, and now doing it at 7 or 8%, that's a huge issue that we don't want to occur. And so it is very easily avoided by doing a deed on that home that says, at my death, this house goes into the trust, and by the work of the law, so does the mortgage. And so now the trustee can deal with the mortgage company through the trust and still not have to go to court, get it sold, pay off the mortgage, and be done with it. So sometimes, now, if it's paid off, sure, there is really no reason not to put your home into the trust. But if there is a mortgage on your home, you really don't want that to go into the trust.
What about for Medicaid purposes, having the home in the trust? Can that complicate things a little bit?
Yeah. Again, a whole nother video, we can go into this, but for Medicaid purposes, your home is typically a non-countable asset, meaning you can own it and still qualify for Medicaid because Medicaid wants to put a lien on that house and get their money back. When the home is in a trust, Medicaid can't get to it because it's not in the name of the Medicaid applicant. And so therefore they can't get to it. So therefore a home that is in a revocable living trust is a countable asset, which is a problem. But don't undo your trust. Don't panic. It's a very easy fix. If you go to an attorney who understands Medicaid and they see that your home is in a trust, they just simply deed it from the trust back to the person who's going on Medicaid. And then there's some things we can do with it there. But yeah, having a home in a trust is a problem with Medicaid. It's easily solved, but it's a problem.
There's a little bonus for you. And you said something really specific that I think is important. You need to go to an attorney that understands Medicaid. That's a whole other video.
Yeah, most attorneys don't. And typically a certified elder law attorney does understand Medicaid and can help you do that. But some attorneys may think they understand Medicaid, but really get this messed up.
That's a
whole nother video.
Well, yep. What I liked is you said something that I was going to bring up when we didn't discuss it beforehand, okay, which is fun. You're getting to see just a tiny bit of our process here. But the due on sale clause is really something that's interesting to me. And I don't have any real personal examples of dealing with this issue, but I've heard a little bit that this is beginning to happen where, it's kind of like the bank has the option to do it. They don't always do it. But in some of these situations with interest rates rising, we're starting to hear some stories about this happening.
If they can do it, they will. Yeah, a due on sale clause means obviously if you sell your home, you've got to pay off your mortgage. Okay. They don't want you,
you can't mortgage the same property 4 times.
Yeah. And yeah. If you sell that home, you have to pay off your mortgage. That's called a due on sale clause. The mortgage is due when you sell. So putting it into a trust, you're still living there. You're still benefiting. You're not selling it, but technically you are to the trust. And so they could enforce the due on sale clause. And I know there's a whole federal statute that says they can't, but I'm just telling you, if the bank wants to do it, they're going to make your life miserable or your attorney's life miserable trying to enforce that. So anyway,
We'll get an email about it, I'm sure.
I'm sure we will. Fourth item that you don't want to go into the trust is life insurance.
Mhm.
And I think you're better to talk about the reason for that than I am.
Sure. Well, we want to be really specific with this idea. Remember, we're talking about revocable living trusts
Revocable
in this
trust.
case, and there's lots of different types of trusts, which we should talk about in other videos.
Sure.
But for a revocable living trust, from a tax perspective, it's the same as you. From the IRS's view, the revocable living trust is not a
Doesn't
distinct
exist.
entity.
Mhm.
But for other purposes, sometimes Medicaid purposes, sometimes with the house thing that we talked about, but really more for probate is where there's a distinction here.
Mhm.
This is how this works. And so if the trust, the revocable living trust, owns the life insurance, there's no liability protection benefit for that, and that depends on the state that you're in. And there's also no estate tax benefit for that.
True.
And so, because it's not a distinct entity from the IRS's perspective, okay? And so, and then, there's some cash value things, but that's really a separate issue altogether. And so, if you own life insurance and you want it to be in the trust, you can have the revocable living trust be the beneficiary of it. You just don't want it to own the life insurance. There's really no need for it, and you're probably going to get a headache from the life insurance company trying to change the ownership.
Yeah. And for higher value clients, you want life insurance to not be part of your estate.
Mhm.
Life insurance, the death benefit on life insurance is part of your estate. And so if your life insurance value is going to throw you into that taxable estate, which is coming down drastically over the next 2 years, then that could be a problem. People don't think of their life insurance as part of their estate. It's just like, yeah, my kids will get $3 million. Well, yeah, but that's part of your estate. The IRS is like, oh, that's your money. You're giving them $3 million. So it's part of your estate. And if it throws you into a taxable event, that's bad. But there's a really particular type of trust, and probably we'll do a whole nother show on this, is the irrevocable life insurance trust. And that's where you can put life insurance into a trust, but it's an irrevocable trust and it's not part of your estate.
Mhm.
And it pays to that trust, and the kids can use that trust to pay off your tax bill or simply keep that amount from being part of your estate and not forcing you into a taxable estate, which is about a 50% tax.
This is a huge thing,
Yeah.
and this is one of those errors that we see all the time, and for whatever reason, it's just like I don't know how people miss this.
Well,
They
I
they
missed
do.
it for years. And when you brought it to my attention to say, Todd, why put life insurance into revocable trust? I was just like, that's just how I was taught to do it. But
That's a fair.
once you think through it, and I think I'm pretty sophisticated on estate planning and Medicaid and all kinds of things. And so if I missed it, I'm sure there are a lot of other attorneys out there who have also missed it. And if you think through it with a financial planner, it really makes no sense to put life insurance into a revocable living trust.
This is the magic of having both sides of this card working together.
Yeah, exactly.
So there's a lot more that we could say about that, but that's a good one, an important one, And really, I don't know that there's any reason not to have life insurance in an ILIT, in an irrevocable life insurance
Sure.
trust.
Yeah.
I mean, they're very inexpensive to set up and operate. It's really not that big of a deal, and the benefits are massive.
Sure.
I mean, could be hundreds of thousands of dollars if we don't screw it up.
Yeah.
That's a
Okay.
high leverage, simple move. So what's the last one here?
Number 5, and this is not that you shouldn't, but it's just kind of a technical thing that I want you to think about is personal property. Your stuff, your TVs, your paintings, your silverware, your furniture,
My wine collection.
your wine collection. There's no paperwork to that. And by law, whoever has that in their hands, whoever has that owns it. Okay. There's no paperwork to it. And so therefore it's difficult to put that into a trust. And typically when you do a revocable living trust, you will do what's called an assignment of property. And you kind of, in magical terms, say all my stuff is owned by the trust. Well, It is, but then again, it's not. And so you just have to be careful and make sure that the successor trustee of your trust knows at the time of your death, and particularly if there's some family issues going on. This is where with a family that doesn't quite get along, the trustee of the trust has to rush in and basically lock the house up. We work closely with a commercial trustee, and he says in his desk or in a closet in his office he has locks, and he can go in, and when one of his clients passes away, he becomes the trustee of the trust. He said, I grab a lock and I go to the house and I lock up that house, because if anyone shows up and takes the TV or takes the silverware or takes the wine collection, there's not a whole lot you can do. I mean, they own it and they've run off with it and it's gone. And so
It's kind of a crazy one.
it is kind of crazy. And so that assignment of property technically puts it in the trust, lets the trustee be able to control it. But from a practical standpoint, whoever grabs it first and runs off with it, they have it. And so you need to make sure, this is one of those discussions. And I'm becoming more of a fan of commercial trustees as we go through this, rather than kids being
Yeah.
the trustee, is so that there aren't hurt feelings. The trustee knows, okay, you've passed away. I'm now in control of this, and boom, they get to work. They lock down that house so that then you can go through the trust and say, okay, this personal property is either equally divided, and they make sure it's equally divided rather than one kid taking the most expensive thing from the house and it not being available. So anyway, it's just one of those things that it's technically there, but from a practical standpoint, it's really not. It's still floating out there, and whoever can grab it and run off with it has it.
These are funny things. Now, thankfully, that's not your family. That's no one you know.
No,
So
no, no.
you don't have to worry about that stuff. But our goal here is just to give you little tidbits to start thinking about and ways to. It's stuff that we see all the time, but average people don't really deal with this.
Mhm.
And this can be stuff that does cause a lot of heartache and a lot of trouble and
Yeah.
strife. And so, if we can avoid that, that's a great thing.
Yeah. So, I mean, our goal here is to educate you on this, and we would be more than happy to help you with that. If you're in Arkansas or Oklahoma, I can be your estate planning attorney. We can also be your financial person pretty much wherever. So,
We've got a great network of professionals that we use to help our clients all over the country, and so we've got a ton of capabilities we haven't really talked a ton about yet, because that's really, to us, that's a secondary issue. The first thing is you need to be educated so you can make good decisions, and we can backfill the talent we need to execute those plans. So overall, these are the essentials that you need to know when preparing your living trust. I hope you enjoyed the breakdown here. Tips and strategies like this are exactly what we share with our clients, and we go even a little bit further in depth with them and walk them through this stuff step by step. How to implement financial planning strategies like these for yourself. And again, we're really big on education. But if that's something you're interested, please go ahead, book a consultation using the link in the description. We'll hop on a quick call and chat about how we can maybe help you. And if we can't help you, very transparently, we'll help you find someone that's a better fit.
sure.
We really care about working with people who think in the same direction that we do, and appreciate our perspective. And that's okay if it's not us. We'll help you find someone, because these these are high value issues.
Yeah.
And so if I tell folks all the time, people that want to work with me, I say, look, if you're not going to take my advice, I have to act as a fiduciary. I can't charge you if I don't think you're going to take my advice. That's not in your best interest.
Sure.
And so,
Yeah.
we'll help you find the right fit. But we look forward to sharing some more of these tips with you in the next video, and we'll talk to you
Okay.
next time.
Thank you.